So we continue. Insurance, the nature of the contract. So insurance is an important part of the modern life. Individuals and business take out insurance to protect themselves from loss that may occur due to damage to property or loss. So remember, we say that whenever you'll be going through these videos, it's always advisable you put your phone on a portrait mode, so that you are able to follow the notes well. So what is insurance? So this is a contract whereby a party known as the insurer undertakes, in consideration for sum of money known as premium paid by insured, to pay sum of money or its equivalent on the happening of the specified future event. The insurance contract is a contract like any other, but with a peculiar principles. The insurance interest or the insurable interest should be beyond the control of either party, and there must be an element of negligence or that there is uncertainty. So the contract dealing with certain future events are either aleatory, contingent, speculative. An insurance risk exists in priori whether or not we insure. However, in a wager, a stake or gamble, there is no insurable interest. So we are saying that the insurance risk exists in priori. So it doesn't mean that when you have not covered your vehicle, it will be involved in an accident, or when you have covered your vehicle, it will be involved in an accident. So insurance risk occur regardless of whether you are covered or you are not covered. So we can go through the parties to the contract as we have discussed in the previous video when we are discussing the terms used in the insurance company. So insurer, who is an insurer? So we say that insurer is the insurance company. This is the insurance company. That is the insurer. Insured is the insurance customer. In this case, the policy holder. So this is the person, that is insurer, is a person who undertakes to pay the sum assured or indemnity when the insured event occurs. To carry on insurance business in Kenya, a person must be a body corporate. That's a limited company licensed by the Commissioner of Insurance to do business. So, insured, this is a person who takes up insurance cover. He is the person who pays the premium and may be neutral or artificial person. The insurer or the insured must have an insurable interest in the subject matter of the insurance. So you see that insurable interest is that you cover what will affect you financially in the event it is lost or it incurs a risk. So if it doesn't affect your financial position, then you do not have insurable interest in that item. So essentials of an insurance contract. Remember, you have said that insurance is a contract between the insured and the insurer. What are the essentials of this contract? The first one is agreement. So, for a contract of insurance to exist, there must be an agreement under which the insurer is legally bound to compensate the other party or pay the sum assured into bracket the premium. This is consideration that passes between the parties to support the transactions. It is asserted that premium is the consideration which the insurer receives from the insured in exchange for their undertaking to pay the sum assured in the occurrence of the event insured against. Any consideration sufficient to support a simple contract may constitute a premium in a contract of insurance. Uncertainty. Remember, when you want to cover your item or an asset or a property, you are not certain that a risk will occur. So the risk covered must be uncertain. You cannot say that you are covering an asset because you know you are covering your vehicle against accident because you know maybe next week it must get involved into an accident. No. So you should not be certain whenever you are covering your property. So the insurance contract is alienatory, contingent, or speculative as it deals with uncertain future events. It deals with uncertain future events. For an event to be insurance, that is, for an event to be insurable, it must be characterized by some uncertainty. Some uncertainty meaning we are saying that you must not be certain that an accident or a risk will happen. So insurable interest, as we have also discussed earlier, insurable interest is an event must be of an adverse nature. The insured must have an insurable interest in the property, life or liability, which is the subject of the insurance. Insurable interest is said to be the pecuniary or financial interest which is at stake or in danger if the subject matter is not insured. It is the basic requirement for the contract of insurance. It is a basic requirement that for you to insure a property, you must have insurable interest on it. So another one is control. So the insurable of the party, the risk as it was held in Re-Sentinel Securities, PLL. The other one is number 5, accidental or negligent loss. Accidental. So insurance can only be effected where loss is accidental in nature or is a consequence of a negligent act or omission. Loss occasioned by international act does not, intention. So a loss occasioned by intentional act does not qualify for indemnity for payment of the sum assured. It was held in the case of Toxleth versus Hampton. So what is a risk? So a risk has been defined as the chance of loss, the probability of loss, or the probability of any outcome different from the one expected. It is the condition in which there is a possibility of an adverse deviation from desired outcome that is expected or hoped for. For individual purposes, risk is measured by probability of loss as the individual hopes that it would not occur. So remember, risk is something that you have covered in other mathematics topics, where we say a risk is a deviation from expected. So a risk is a deviation from the expectations. So when you expected to receive 80 but you end up receiving 60, there is a risk. So risk is a deviation from expectation. In mathematics also, remember that risk is measured using the standard deviation, the variance. You also have the coefficient of variation. So those are the measures of risk. So formation of a contract. So a contract of insurance comes into existence when an offer by the proposer is accepted by the insurer. The proposer makes the offer by completing and submitting to the insurer the proposal form. This form seeks information in relation to 1. Particulars of the proposal, particulars of the subject matter, circumstances affecting the risk, and the history of attachment of the risk. The proposer signs a declaration at the bottom of the form to the effect that the answers given constitute the basis of the contract between him and the insurer. The declaration is referred to as the basis of the contract clause. Submission of the proposal form to the insurer constitutes the formal offer by the proposer. The insurer is not bound to accept the offer. However, he may, as he assesses the risk, extend a temporal cover to the proposer. So that is how the contract of insurance starts. So you have like for example, you have the insurance brokers who sells the insurance contract. We are saying that the insurance contract is complete when the insurance company accepts your proposals. So it's the customer who requests the insurance company to take his or her cover. The insurance company may accept to cover his risk or may reject. So the moment the insurance company accepts to cover that risk, that is when the contract starts. So, acceptance of the proposal form. The insurer is not bound to accept the proposal offer or the proposer's offer. However, if accepted, it signifies a contractual relationship between the two. The insurer may signify acceptance of the proposal form by formal communication. So this is where the insurance company sends its acceptance report to the insurer, to the insured. So number 2, by conduct. By conduct, it means that the insurance company may not give a formal acceptance, but the moment the insurance company start receiving the insurance premium, it simply means that it has accepted to cover that risk. 3 is the issue of the policy. So remember we said that the policy is the insurance cover document, the document that lists down the terms and conditions of the contract. So acceptance and retention of premium raises a presumption of acceptance of the proposal form. So you have classification of insurance contract. Classification of insurance contract. So insurance contract may be classified on the basis of, number 1, the event insured. The event insured. So the category of insurance derives its name from the event, e.g., fire. So in case you insure your property against fire, your insurance contract will be referred to as fire insurance. In case of burglary, it will be referred to as burglary insurance. In case of marine, it will be referred to as marine insurance. In case of fidelity, it will be referred to as fidelity insurance. And in case of motor, it's also referred to as motor insurance. So those are, in most cases, they are referred to as general insurance. General insurance, where the insurance company is covering the property. It's not covering the life. It's not a life insurance. It is a general insurance covering the property. So the interest insured is the second classification. The insurance, the interest insured. So the classification places contract in three categories, namely the personal insurance, that is life insurance. Remember, life insurance covers the life of a human being, it doesn't cover a property. So the other one is property insurance, that is the one that we have referred as the general insurance. And the other one is the liability insuring. So this is a contract that is taking over the liability of a person. So we have the NSSF, the National Social Security Fund. The NHIF is the National Hospital Insurance Fund. And then we have the third party, motor insurance. Remember, in Kenya, it is compulsory for that every vehicle using our public roads to have a third party motor insurance. That one is compulsory. It is against the traffic regulations to have a vehicle on the road without a third party motor insurance. Number 3, the nature of the contract. So we have the nature of contract, the contract of indemnity. Remember, you see that indemnity is where the insured takes out the policy on the understanding that when loss occurs, he will be compensated for a loss. And this is the property insurance, e.g. fire, burglary, or marine. Then you have non-indemnity. So as you are discussing the terms in the insurance contract, you see that indemnity is that situation where the insurance company, in the event a customer incurs risk, the insurance company will step in to compensate you to get back to your previous position that you were before the occurrence of the risk. So that is the contract of indemnity, or simply that is the meaning of indemnity. But we know that sometimes people will take life insurance. When we take life insurance in most cases matures at death of the insured. The question is, can the insurance company compensate a person to get back his life in the event that person dies? So it is not possible to compensate life of a human being, and therefore the insurance company states that as far as money can do, the insurance company will compensate. As far as money can do, remember, money cannot buy back the life of a human being. So what the insurance company do is to compensate the beneficiaries, to compensate the beneficiaries of the deceased, where the deceased life had been insured. So that is non-indemnity. So as you can read, non-indemnity contract is a contract whereby a party known as the insured takes out the policy to secure the payment of a sum certain in money when risk attaches, e.g. life insurance. So as far as money can do, the insurance company will compensate. But we know that it cannot compensate life. It only pays money to the beneficiaries. So the next one is whether private or social. Private insurance is optional. So private insurance is optional while voluntary. Social or compulsory insurance is a statutory requirement, e.g. third-party motor insurance. That one we have just said that it is compulsory. It is compulsory. And maybe also the NHIF is also a compulsory cover that people should undertake insurance cover against their health. So the other one is basis of the program. The basis of the program. So insurance, reinsurance, and this is the contract in which the insurer insures himself with the reinsurer against the risk he has insured against. It may be voluntary or compulsory. So another one, we have the principles of insurance. The principles of insurance. So principles of insurance, I know that we have just discussed some of them, like the insurable interest. We have just discussed what it means. We have just said that insurable interest, you only insure that item that is yours. You only insure your own asset, and that means that if in the event your phone is lost, you incur the financial loss, then you have insurable interest on your phone. But if another person's phone is lost, you will not personally incur that financial loss, and therefore you don't have insurable interest on another person's phone. So insurable interest is simply means that. So this is the financial or monetary interest at stake or in danger in the subject matter if the subject matter is not insured. It is the interest a person has in the subject matter which he stands to lose in the event of its loss or destruction. So the subject, to ascertain whether a person has insurable interest in the subject matter, the courts employ the following rules. Rule number 1, there must be a direct relationship between the insured and the subject matter. The insured bears any loss or liability arising. The insured must have legal or equitable interest / right in the subject matter. The insured interest / right must be capable of financial / pecuniary estimated or qualification. So number 2 is the disclosure. / utmost good faith. Remember, we say the contract of insurance is a contract of utmost good faith. Utmost good faith, it means that you are supposed to reveal all the required information about you or about your property to the insurance company when you are undertaking the insurance cover. So you are supposed to give all the required information to the insurance company, and therefore the insurance company will decide whether it will be able to cover your liability or to cover your property against the risk. So you have a duty to reveal all the required information about your property. So we say the duty to disclose exists throughout the negotiation period. It generally comes to an end when the proposal form is accepted. So what is the effect of non-disclosure? So what will happen if you fail to disclose all the required information to the insurance company? So the non-disclosure of a material fact by either party renders the contract voidable at the option of the innocent party. In London, Assurance Company versus Mansell, a case of 1879, when responding to a question in the proposal form, the proposer stated that no other insurance had declined to take his risk. In fact, two companies had previously declined to insure him. Subsequently, the insurer sought to avoid the contract on the ground of non-disclosure of material fact. It was held that the contract was voidable at the option of the insurer for the concealment of material fact. A similar holding was made in Horn versus Pollard, a case of 1922. Although the contract of insurance is one of utmost good faith, certain matters need not to be disclosed. Certain matters need not to be disclosed. So, one is provisions and proposition of law. So what is in the Constitution or what is already given in the law, you don't have a duty to keep repeating it. So law, in case it's an item that is already in the law or a provisions of the law, then you don't have a duty to reveal it. So another thing is unknown facts, as was the case of Joel versus Law Union and the Crown Insurance Company. So in case even yourself you don't know, you don't have the fact, so you don't have a duty to reveal it. Another one is facts known by the other party, the facts known by the other party. Another one is the matters of public notoriety, as was the case of Bates versus Hemit. So matters of public notoriety simply means that something that is known by everyone. So everyone knows. So everyone knows some matters. When we talk of matters of public notoriety, we simply means that this is something that is known by all. By all. Maybe something that involve the government, or maybe involve the law that is already existing, or maybe a calamity that has happened, like COVID-19. So it is known by everyone that COVID-19 was there and it affected this and that. So that is something that is of public notoriety. So number 3, indemnity. We have also discussed indemnity. Indemnity, we have said that this is where the insurance company will step in to compensate you to get back to your financial position where you were before the occurrence of the risk. Before the occurrence of the risk. Remember, I have said that as much as money can do. So as much as money can do, the insurance company will pay you or will step in and compensate you to get back to your previous financial position. So indemnity is the principle, or this principle means that when loss occurs, it is the duty of the insurer to restore the insured to the position he was before the loss. The insurer must, so far as money can do, put the insured to the position he was before the loss. Indemnity means that there should be no more or no less the restitutio in integrum. So we are saying that the insurance company is not there to help you to make profit. It is only there to restore you back to your previous position where you were before the occurrence of the risk. So the principle of indemnity is given effect by subordinate principles, e.g., the principles of subrogation, salvage, reinstatement, contribution, and apportionment. So that one we shall see later. So the subrogation, salvage, reinstatement, contribution, and also apportionment. That one should be apportionment. So apportionment should not be appointment. It should be apportionment. So what do we mean by subrogation? So subrogation, this means that after the insurer has indemnified the insured, he steps into the shoes of the insured in relation to the subject matter. So, in the event that a vehicle is involved on an accident, and then the insurance company pays the owner of the vehicle with a new vehicle, then the old vehicle which has been involved in an accident will not be given to the customer. It will now be the property of the insurance company, because when you are given that vehicle to repair and also you have been paid the new vehicle, then it means that the insurance company has helped you to make profit. Yet that is not within, that one is not within the spirit of the indemnity, not within the spirit of indemnity. So it means that after indemnity, the insurer becomes entitled to all the legal and equitable rights in respect to the subject matter previously exercisable by the insured. Subrogation facilitates indemnity by ensuring that the insured does not benefit from the contract. Number 5, we have salvage. So, this is the recovery of the insurer of the remains of the subject matter after indemnity. It is the part of subrogation and facilitates indemnity. It is justified on the premise that the amount paid by the insurer as indemnity includes the value of the remains. So what we are saying is that the moment you are paid in the new vehicle, the remains of that old vehicle should now be taken to be a property of the insurance company. So we are saying that it is part of subrogation. So the other thing is reinstatement. So this is the repair or replacement of the subject matter in circumstances in which it may be restated. So in the event that vehicle that has been involved in an accident, it can be repaired, and then the insured will be satisfied the way it is after repair, then it will be okay for that vehicle to be repaired and then given back to the insured. But we are saying that so long as the insured is satisfied, so most indemnity policies confer upon the insurer an option to pay full indemnity or reinstate the subject matter. So the insurer must exercise his option within a reasonable time of notification of the loss and is bound by his option. If the insurer opts to reinstate, the subject matter must be restated to the satisfaction of the insured. So what do we mean by double insurance? So as we were discussing the terms used in insurance company, that is used in the insurance contract, we say that double insurance is where the insurer undertake two insurance cover in the same subject matter. So for example, you have a lorry, and that lorry you insure it against accident in a company known as ABC Insurance Company, and you also insure the same vehicle against accident in XYZ Limited. So those are two insurance company covering one subject matter or one vehicle. So what happens? So this is a situation whereby a party takes out more than one policy on the same subject matter at a risk with different insurers, but where a total sum is insured exceed the value of the subject matter. So another term is contribution and apportionment. Contribution and apportionment. Remember, the spirit of indemnity. The spirit of indemnity is that no person should benefit from insurance contract. To benefit here, I mean that if you had one vehicle before the accident, then when you get involved in an accident or the vehicle is involved in an accident, the insurance company pays you 2 vehicles. Then it means that you have benefited, and that is not within the spirit of indemnity. Indemnity means that you are restored back to your previous position. So if you had one vehicle, you still be compensated one vehicle. But when you undertake 2 insurance cover against one vehicle, it doesn't mean that you are supposed to be paid by each insurance company a lorry each. So you'll be having 2 lorries. So that is not within the spirit of indemnity. So what they should do is that the 2 insurance companies should share the risk. So both of them should pay according to the ratio. Maybe you insured. They should make sure that you are compensated just one lorry. The two companies should come together and contribute, and that is what we are calling contribution. What about apportionment? Apportionment is where we apportion those claims in the two insurance companies. They apportion. So if one is receiving 70% of the premium, then it should compensate 70%. If this one other is receiving 30% of the premium, it should also compensate 30% of the claim. That is simply what we mean by apportionment. Contribution is when the 2 companies are coming to contribute to pay back the cover or to pay back that vehicle. So if an insured has taken out more than one policy on the same subject matter, and the risk with different insurers, and the loss occurs, the twin principles of contribution and apportionment apply. If insured claims from all the 2 companies at the same time, they apportion the loss between themselves on the basis of sum insured. Each insurer bears part of the loss. This is the principle of apportionment. B, if one of the insurers makes good the total liability to the insured, such insurer is entitled to recover the excess payment from other insurers. This is the principle of contribution. This principle is to the effect that an insurer who has paid more than his lawful share of the loss is entitled to receive the excess from the other insurer. So that is the principle of contribution. So another one, we say that the principle of contribution is equitable. Equitable, remember, it comes from the law of equity. So an insurer is also entitled to contribution of the following if the following conditions exist. Number 1, there must have been more than one policy on the same subject matter and risk. So the policies must have been taken out by or on behalf of the same person. The policies must have been issued by different insurers. The policies must have all been enforced when loss occurs. All the policies must have been legally binding agreement. And number 6, none of the policies must have exempted itself from the contribution. So the twin principles of contribution and apportionment facilitate indemnity. So number 9, abandonment. So abandonment. So you are supposed to abandon that old asset that has been involved in an accident as you receive a new. If you have received a new vehicle, then you are supposed to abandon the old one. When you abandon or you leave it. So this is the surrender of the insured of the remains of the subject matter for full indemnity. It entails the giving up of res, that is the residue or the remains, to the insurer for indemnity. This principle has its widest application in the marine insurance, but generally applies in case of partial loss, construction or constructive total loss. The insured must notify the insurer of his intention to abandon the subject matter. However, it is for the insurer to determine whether or not abandonment is applicable. If the insurer opts to pay full indemnity, it signifies the sufficiency of the insured notice, and it is an admission of liability. The insurer becomes entitled to the remains of the subject matter. So 10 is the proximate cause. So what causes the risk? So when you insure your vehicle against accident, what really causes that accident? So did you cause that accident voluntarily? So the proximate cause. So did the vehicle get an accident? Or when you cover your vehicle against accident, will you be compensated if the accident is caused by fire? So proximate cause. An insurer is only liable where loss is proximately caused by the insured risk, and not liable where the risk is accepted. The principle of proximate cause protects the insurer from undue liability. Under this principle, the proximate and not the remote cause is to look into causa proxima non remota spectator. The proximate cause of an event is the cause to which the event is attributable. It is the cause which is more dominant, direct, operative, and efficient in giving rise to the event. Courts have not developed any technical test ascertaining that the proximate cause of an event is. They rely on the common pleas test of the reasonable man, and that among competing causes. One must be more dominant than the rest. The proximate cause need not be the last on the chain, but must be the most operative in occasioning the loss. So, termination of the contract. So how does the contract of insurance comes to an end? How does the contract of insurance come to an end? An insurance contract may come to an end or terminate in any of the following ways. 1. Payment of indemnity. So in the event a vehicle had been involved in an accident, then the insurance company had paid for that claim, has already compensated the owner, then it means that the insurance contract has come to an end, unless now you start a new contract. So the sum assured in the event of total loss. In the case of partial loss, reinstatement does not terminate the policy. Another one is mutual agreement. So mutual agreement is where the two parties, the insured and the insurer, comes to an agreement to terminate the contract. That is mutual agreement. So the parties may at any times agree to terminate the contract at the instance of the insured. The property insurance, the insured becomes entitled to the surrender value of the policy. In life policies, if the insured has been a bona fide insured for 3 years, he is entitled to 75% of all the premium paid, inclusive of any bonuses and the interest payable. 3, you have the breach of conditions or warranty. So the insured is entitled to apply for cancellation of the policy if the proposer breached a condition or warranty to procure the policy, e.g., misrepresentation or non-disclosure of material fact. Another one is lapse of time. If the contract was to last for 30 days, after 30 days the contract automatically terminates. If it was a 1-year contract, then after the end of the year, the contract automatically terminates. So, indemnity contract or property insurance lapse after 1 year, it is the duty of the insured to renew the cover. Another one is operation of the law. So these are circumstances which render the maintenance of the policy impossible, e.g., winding up or liquidations of the insurer. Number 6, sale of the subject matter. So if you had insured your vehicle and then you sell that vehicle, you cannot continue paying insurance premium for a vehicle that you have already sold, because from that point you don't have the insurable interest. So those are ways under which the insurance contract will be terminated. So that marks the end of that topic, the contract of insurance or the law of insurance. That marks the end of that topic. It's good to understand all the principles of insurance. You also need to differentiate between insured, insurance, and the insurer. What is risk? What is claim? What is the insurance policy? All those things, it's good to know what they mean. Circumstances under which a contract of insurance can be terminated, it's also good to know them. Then how a contract of insurance is formed or is entered into, that's another thing that you need to know. So I hope you'll be able to follow those notes well.